Good morning, Your Honor. Matthew Reardon appearing on my own behalf.
Hello, Mr. Reardon. Good to have you with us today. How about on the defense side?
Norman Child again, in Your Honor. City of Galveston, Officer Osteen, and Sergeant George.
Christopher Lindsay for UTMB.
Okay, great to see all of you. My understanding, to start off, Mr. Reardon, I know there's some other defendants. Has service been accomplished?
Your Honor, I received the court's notice and prepared to discuss the scheduling order, all pending matters. Now, I guess the first thing that I want to address is there are two.
Hold on. Time out. My question is, for you first.
Yes, sir.
With other defendants in the case, have you served them?
That's what I'm trying to say is there was actually two of them that were returned for Lafayette County, Mississippi, two deputies. They're no longer with the department. I've been trying to locate them. The department has been uncooperative with disclosing what department they've gone to. So in that regards, I was hoping to, I know you had said about how the court doesn't do motions to compel, but at this point, Your Honor, I'm not allowed into Lafayette County. These are defendants in this civil rights case. And based on the call recordings that were obtained yesterday, they are obstructing and trying to keep these defendants in their and where they can be served, where they're at, concealed. And so the court should take issue with that, just like I take issue with that. And I think that needs to definitely be addressed, Your Honor.
Let me start off with saying, obviously, the defendants have been named in the case. You got to serve them to properly make them to hear before us. I noticed that there's two motions to dismiss that have been filed. One on the 3rd by UTMB. That means your response, Mr. Reardon, to that is due 21 days later, or on the 24th. And then a motion to dismiss was filed yesterday by the City of Galveston, Jack Doherty, William Osteen, and that response is due on November 4th. Now, because of the nature of this case, meaning there's some qualified immunity, some sovereign immunity issues, discovery is not appropriate until those preliminary issues are resolved. UTMB filed a motion to stay discovery, which is docket 27, which has been referred over to me. And candidly, my hands are tied on that. There'll be no discovery in this case until we get a ruling on the motion to stay. So the motion to stay discovery, docket 27, is granted. And
Your Honor,
the response from you, hold on, Mr. Reardon. Response from you on the motion to dismiss, we'll get a reply, and then we'll get a ruling. If the motions to dismiss are granted, obviously the case is over. If the motions to dismiss are denied, then my request or my order is to you all get together and propose within 5 days of an order denying the motion to dismiss, a scheduling order so we can put that in place in the case. I'm sorry, Mr. Reardon, you're going to say.
Yeah, Your Honor, if I may. So that was actually one of the other things I wanted to address. I intend to file an amended complaint in this to add critical facts that have come to my attention since the initial filing. This will likely affect the defendant's current motion to dismiss and should be addressed before we set a final deadline for that response. And even just right here with granting the motion to stay, there are two separate courses right here as far as the sovereign immunity claim with the UTMB defendants. I reserve the right, and I intend to either name UTMB as a to name their executives personally, individually, or to seek declaratory relief in the UTMB case, but to hold the entire case over on stay when this is. I feel like this is going to bind the case up. I've had bad experiences with these cases getting put on stay, and I think that this case deserves a lot more than getting put on a stay and looking at it dismissing the case on some trivial ground that's just going to get appealed.
Well, let me say this. Obviously, all the cases, Judge Brown and I say this very seriously, all the cases are important. the law is clear that until the sovereign immunity issue, qualified immunity decision are made, the discovery cannot proceed. And the Fifth Circuit is clear as day on that.
It's also clear on the other constitutional rights.
Well, if you want to file an amended complaint, we're always going to give the party an opportunity to amend their complaint at least once. So if you'd like to file an amended complaint, why don't we pick a date to do that? So we have a date for you to file the amended complaint.
Yes, sir.
If you file that amended complaint, and then if UTMB, Galveston, or the individual defendants want to seek to move that to dismiss that one, they can do that.
Yes, sir. I think, yeah.
I thought I was going to say next Friday on the amended complaint. Does that work or not work?
Next Friday can work for me, Your Honor. I was going to say, suggest 8 to 10 months for a discovery period after that. But yeah, I think if I could have until next Friday, I can have an amended complaint in, and I think that I can.
More time, I'll give you more time. File the amended complaint, the quicker we can reach the resolution of the sovereign immunity and qualified immunities.
Sure. Yeah. Well, this is a case, and in fact, with recent events that have come up, it's something that doesn't need to be. I'm not trying to overrush anything because more and more things are coming out as time goes on.
I'm just trying to put a schedule in place. So you tell me, when do you want to file the amended?
Okay, so I think if you could give me, I would say, let's make it, if you don't mind, Your Honor, let's make it that following Monday, just to give me that extra weekend. If I need it, I don't think it's going to really matter that much, Friday to Monday, but just giving me that extra weekend right there in case I need it to get everything prepared. And
I don't like setting Monday deadlines.
Okay.
A weekend. I don't like that. So I'll give you Tuesday, the 28th of October.
That works perfect for me, Your Honor.
Okay, so just so we're all clear, you'll file an amended complaint if you so desire by October 28th. The veterans will have the time departments, will remember the rules, as to respond. And in the meantime, the discovery is stayed until a resolution of assuming the motion is filed on the amended complaint, so the qualified immunity and sovereign immunity issues are decided. And then if the motion is denied, the motion is dismissed or denied, parties are provided closed docket control within 5 days.
Okay. Yes, sir. It's very concerning with the Lafayette County Sheriff's Department. And
wait, hold on.
Yes, sir.
I'll give you a chance. I promise you. Mr. Giles, does that work?
Yes, Your Honor.
Mr. Lindsay? Yes, Your Honor. Okay. Yes, sir, Mr. Reardon.
I was just simply I'm not trying to hold you up, Your Honor, but it's very concerning to me with the Lafayette County, Mississippi Sheriff's Department. 2 of these defendants, which came out of their department, conveniently, when it came time for them to get served, are no longer with the department, and the department doesn't want to say anything about where they went. They were working for the department. I think that there should be an obligation. In fact, I think this encroaches on obstruction, the fact that they're trying to conceal this information. I mean, this is the government. They shouldn't be able to sit on it.
Those entities are not before me today, so I can't do anything with respect to that. We're going to have the amended complaint. Let's test it on the motion to dismiss, and we'll see what happens if the case proceeds or it gets dismissed. So with that, anything else we need to address today, just on scheduling issues from the defendants?
No, Your Honor.
Plaintiffs?
No, Your Honor.
Great to see all of you. Thank you very much. We look forward to the amended complaint on October 28th, Mr. Reardon. Have a great day, everyone. Thank you.
Thank you, Your Honor.